Good morning, everybody. So we decided to do the press conference because the journalists at the moment are sending us a large number of detailed or individual questions. We felt it was better to rather do it in this format because on the scenario of trickle feed, we are entertaining a large number of calls and queries every day. We're just not able to cope with the volume of interest. So yesterday, thank you for your patience. We asked many of you to wait until this morning, and we can perhaps just give you an update. Most of you wanted to know what had happened to the meeting between the South African Police and Home Affairs and the Sheriff and the City the day before yesterday, and we can now give you that information. So by way of a recap, it's perhaps worthwhile reminding you that this most recent stage in the developments started on Sunday, on the 1st of March. The city undertook an operation in Greenmarket Square with SAPS under the authority of the Sheriff of the court. Remember that during the implementation of court orders, the Sheriff drives that process, as provided for in the court order granted on the 25th of February, and maybe later on I'll just remind you of what the contents of some of that court order is, specifically in relation to this matter. The operation was preceded by a 7-day verification process by the Department of Home Affairs of persons who'd been residing in the public spaces around the Central Methodist Church. The Greenmarket Square operation was conducted with no resistance from the refugees, as everybody involved in the operation understood the process, and they were given several opportunities for assistance in reintegrating into the communities where they stayed in October last year. The city is in the process of assisting the refugees with reintegration, and many of them have indicated their willingness. However, some of the refugees who were removed from the site then invaded the grounds of the St. Mary's Cathedral, and they were forcibly removed from there by the South African Public Order Policing after the church had laid trespassing charges. From there, the group moved to other public open spaces within the CBD, specifically the Mackenzie Street Park, where they were then in contempt of court. And I'll just unpack in a moment what exactly the court order says in that regard. On Monday, the 3rd of March, the city's enforcement agencies undertook to act against the group. Initially, there was resistance from some in the group, but we ultimately negotiated with them a peaceful walk to the police station, where we accompanied them to SAP Central, escorted by our enforcement agencies, to be placed under arrest as per the court order. The South African police, however, declined to obtain the persons for contempt of court, as instructed by Clause 1 and Clause 3 of the interim court order. The interpretation that they have of Clause 3 of the court order is that the sole duty of SAPS in this regard is to protect the sheriff when he reads out the court order. The South African police have also indicated that they want the city to return to court, that they're not willing to engage in any arrests as per the court order. They've said that in 2 meetings in the last few days, and that they do not believe that they can arrest their persons for the contravention of the court order. In terms of Clause 6 of the order, the city is compelled to comply for further relief from the Western Cape High Court in terms of a clarification of the roles as stipulated in Clause 3. So the court order says that the city may, on the same application, return to court if there is contempt of court and there is no relief in the matter. So we are now left with that as our only resolution, and I can now tell you that the city will be returning to the Western Cape High Court for further relief in respect of the refugee situation that has been taking place in the Central Business District for almost 5 months now. We will specifically revert to the High Court for relief in terms of Section 6 of the order that reads that in the event of non-compliance with any of the provisions of this order, the applicant is granted leave to approach this court on the same papers, duly supplemented, for any order of civil contempt and or further or appropriate relief that may be necessary. The city is continuing to enforce its order and to liaise with all of the role players to be able to make it possible to do so. The city is again offering those occupiers who are willing to reintegrate into their former communities transport to do so. Some occupiers have indicated that they do not want to do so. However, most appear to be willing to accept reintegration. The city is also offering those who need temporary assistance to seek access to private shelters in accordance with the rules of access or admissions of those facilities. In light of the very significant complaints arising from residents and businesses in and around Alberta Street, the city has and will continue to do everything within its mandate to protect the interest of the residents and the businesses and visitors by enforcing its bylaws, and will hold those accountable for the court order. So I can tell you that as of this morning, we have, during yesterday and this morning, also been attempting to engage the persons on the street to offer them assistance. Twice before the court ordered the screening process, which took place at Maitland Civic, the city had made available facilities for people to come to be interviewed and assessed and to assist with reintegration. I can tell you that that assessment process tells us that there were 781 foreigners who went to Salt River. Of those, 538 had papers to be legally in South Africa. 236 had no immigration papers. There were some arrests resulting from forged or fraudulent papers. 236 were given 14 days to apply for asylum seeker or refugee status. Some of them disposed of the documents on the scene there, but others took it away with them. There were 226 children at the start of these proceedings. There are now 42 children left on the scene. I will also tell you that if I tell you now that there are 781 people who were assessed at the Salt River facility, that when we did the survey the first time around, there were 685. So the numbers had grown in that interleading time by around 100 people. This is corroborated by what the local businesses and informal traders also told us, that there was a steady addition of people to the site at Green Market Square. So just perhaps to remind you of what the actual provisions of that court order were, and I think the relevant component is Section 1.1. Court order said that that the respondents are to refrain from the following conduct in the sections of Long Market and Berg Streets, including the sidewalks and Green Market Square, Cape Town, and anywhere else in the city of Cape Town. Intimidating, threatening, harassing, or assaulting, or in any way interfering with the applicant's officials, or in any way acting on their behalf or involved with the law enforcement or affected area. 2, damaging any of the applicant's assets or facilities or properties, preventing persons from entering or leaving the affected area, or contravening the applicant's bylaw relating to streets, public places, and the prevention of nuisances, 2007, without derogating from the generality of the aforegoing. In other words, the issues that they're interdicted from doing include staying overnight or sleeping anywhere, making fires, doing clothes washing, conducting personal hygiene, including ablutions, urinating or defecating. They are not to occupy any structure, object, material or substance erected, deposited, packed or left on the street, sidewalks or any other public spaces of the affected area. So with that, the court order also said, Section 3 or Clause 3, and this is important to understand, that the sheriff, assisted by the South African police if necessary, be authorized to take such steps as are necessary in the circumstances to enforce any order granted by this court. So you will understand how we ended up taking them to the South African police on that Monday in order to give effect to Clause 3. The issue diverting to the Court 2 is in relation to Clause 6 that says that in the event of non-compliance with any provision of this order, the applicant is granted leave to approach this court on the same papers, duly supplemented, for an order of civil contempt and or further and appropriate relief that may be necessary. So that's where we find ourselves now. If you can understand that after having left Green Market Square and some having attempted to invade the St. Mary's Cathedral church grounds, people then relocated on a piece of public space. That is an explicit contempt of the order as I read out to you in that Section 1. We then invoked Section 3 and moved people to SAPS so that we could arrest them in terms of the requirement of the provision under Section 3. SAPS then declined to detain the persons, and I will remind you that that is not a new occurrence. when the original eviction order took place in October last year, I think 8th of October, when that eviction order took place and people settled in front of the Methodist Church, SAPS during those scuffles arrested just over 100 people, 104 or 106 or something to that effect, and within an hour had released them, in other words, had chosen not to detain them. So this is a recurrent view that SAPS is taking, that they will not detain the persons, and that makes it now impossible for us to give further effect to the court order as it is. The city does not maintain or undertake holding cells as a local government. The Act says that when we arrest somebody, those persons must be detained in the holding cells of the South African police at the nearest police station as soon as possible, and that's what we attempted to do. So you'll appreciate that we now find ourselves in a situation where we have little choice but to revert to court under Clause 6 and to go ask the court to explain what must happen now. Effectively, what you're doing is you're asking the court to give clarity to the role of the sheriff and the role of the South African police, and I suspect the role of the Department of Home Affairs in this regard in terms of giving relief to persons. I want to just unpack one other issue that I suspect will come up, and that is the issue of the assistance that the city may provide. So during the screening process that is covered under Clause 4 of the interdict, the persons who we screened, the majority said that they do not believe that they can live in South Africa anymore, that South Africa is not a viable home for them regardless of the accommodation scenario. They want to be moved on to another country. So I think by now you've understood the UNHCR and the Department of Home Affairs' view on this, and that is not legally possible. While people are free to make individual applications for relocation, the UNHCR and others say that there is no mechanism for the collective relocation of individuals under these circumstances. And that is beyond local government's ability or power to influence. That's not a competency of ours in law or in the Constitution. The other mechanism prescribed in that Clause 4 is that when we've interviewed the people, they must give us contact details, including the addresses where they were before, their names, including fingerprints and photographs potentially, so that we may understand if there's any particular reason, and the order refers to particularity of incidents where they were victims of crime or xenophobic violence that would make it impossible for them to return where they were living in October last year. We have asked those questions, and many of the people have given listed examples of how they were brutalized, but a very large percentage declined to give any address of where they lived before, simply giving the address of Green Market Square. So it will not be possible for us in those circumstances to verify the circumstances, and that makes it difficult to give full effect to Clause 4 of the order, of the interim order. However, some did give addresses and did give particularity of their circumstances, and the order then says that we must then, within the framework, within our policies of the city, assist them as we can. And that assistance, the assistance we have available to persons under those circumstances, be they foreigners, be they locals, be they any South African or otherwise, is access to a night shelter. So we did consult all the night shelters, and as of yesterday, when we went back to the sidewalk and used a loud hailer to inform people that we have bed space available, the available bed space for them was 171 spaces for which they would qualify. They would need to meet the admissions requirements of these facilities, in that the night shelters don't belong to the city. We subsidize and support them, but they don't belong to the city, and there were 171 spaces. There were people who indicated they were willing to go last night and again as of this morning. But there is a complicating factor in that it appears that the people who are on site are being intimidated by some of their leadership. There were people who said that they were willing to go, and where the leadership then stepped in and said no, they are not able to leave. And so it appears that quite a few people there function under fear of some of the refugee leadership, and that perhaps in the absence of that may well have been willing to take up reintegration options as it is now. In fact, a journalist who called me yesterday relayed that very same conversation to me, having just spoken to the refugees who indicated as much to her. That again is confirmed by a sergeant that is currently on site for Metro Police, Deputy Metro Police Chief Annelien Marais, who sits next to me to my right, 2 seats removed, so that we don't confuse her with you, Sean. Maybe I should have just introduced, although I suspect you may know them by now. This is Deputy Chief Sean Smith of the Law Enforcement Service. He has been involved in many of the operations and in the discussions with SAPS and others. To his right is Deputy Metro Police Chief Annelien Marais and the Ward Councillor, Councillor Dave Bryant. So this morning, one of the sergeants who are on site confirms for us that they have been engaging since 6 a.m. with people there, and that there is substantial pressure from leaders for people not to leave. There's also a complicating factor now in that attorneys have entered the situation, and that there now are attorneys who are advising their newly acquired clients not to leave the street and not to accept reintegration. So it is being made very difficult to give the assistance that is within our legal means. That will bring me to the question that I suspect some of you may ask about alternative accommodation and why the city resisted that option initially. And I have explained this many times, but for the benefit of those who may not have heard, is that there is a substantial precedent-setting issue here which we have to be very careful of. You'll see that even the editorial of one of our daily papers yesterday spoke to this and clearly understood the issue. We are in a situation where what we do here not only has implications for the future of our city, but for other cities around South Africa. It will be precedent-setting, and I can tell you at least one other local authority has called me and said, please do not get this wrong. You will have massive consequences for all of us. The issue is not the 200 refugees who currently find themselves on the sidewalk. The issue are the thousands more that we know reside in our city, in excess of 160,000 apparently, asylum seekers and refugees. And whilst under any normal circumstances the city is willing to avail any service to those refugees or asylum seekers that we avail to anybody else, access to libraries, clinics, Wi-Fi access, access to employment opportunities where they may legally do so, access to informal trading permits, there is no service that we will give a South African that is not legally denied a refugee or asylum seeker that we will not make available to them. So the city doesn't have a xenophobic approach or a hostile approach to refugees in this regard. But what we must do is treat the refugees and the asylum seekers the same way as we treat local citizens. And if we are not able to make available to local citizens emergency accommodation when they are struggling to make ends meet, struggling to see again employment, all the circumstances that refugees listed for us when we interviewed them. I can't gain access to a job. I'm unable to pay rent, and I'm unable to find satisfactory accommodation. I'm struggling with crime. Those circumstances apply to many or most South Africans on a daily basis. So there is not a differentiation between the foreign nationals who are here and the South Africans who are here, and the city can't make any legal distinction between them. There is not a special mechanism for relief to the foreign nationals that we have. So you will say, well, City, what did you do in 2008? Well, 2008 was very different. In 2008, we invoked a piece of legislation called the Disaster Management Act. And what that did, it has allowed us emergency measures in order to roll out services to people. Because there was widespread xenophobic violence, and I know I went on ride-alongs in response to that and watched SAPS and Metro Police trying to keep the peace and prevent people from looting the homes and shops of foreign nationals. I was personally present for nights on end and went to visit people in halls where they were hiding and where they were being offered sanctuary. That did not transpire this time. So you cannot invoke the act because there is no police record, no case, no affidavit, no statement, no evidence, no crime threat analysis or record within the police of such xenophobic violence in Cape Town that would have permitted us to invoke that act, which means we would need to work through the normal housing provisions. We've had this conversation with the Human Settlements Department in the city and even at province, and there is no legal mechanism for us to invoke special provisions for foreign nationals. The matter is complicated by the fact that all of them will not appear on housing waiting lists. So you will in fact have no legal basis to assist them if they're not on the housing waiting list. You will effectively be queue jumping for everybody who's already on the waiting list. And I think with what you know about people in South Africa and their feelings about housing and the sensitivity of housing, is that if you had to start prioritizing first the 200 and then as many of those 160 to 170,000 refugees as may then step forward and claim the same relief as per the precedent you've just set, you then have a situation where you may potentially have to accommodate tens of thousands or hundreds of thousands of people before you're again able to meaningfully render services to South Africans. And I think that might very well precipitate the xenophobic violence we're keen to avoid. So on the issue of precedent, it is not possible for us, and that's why without being hostile to either the difficulty they find themselves in, or their nationality, or the fact that they're not South African, and I will tell you that I have great compassion for foreign nationals. When I was the ward councillor for the Atlantic Seaboard, I created the Atlantic Seaboard, entered monthly meetings with them, had portions of the conversation translated from French, and worked very hard to include them in the community. We co-opted in every one of the community structures a foreign national or a refugee, so that we ended up talking to them instead of sitting in those meetings talking about them. And that changed the dynamic substantially, and that many of the foreign nationals, Alain, John, others, walked with us on the Yellow Bib and Neighbourhood Watch patrols we subsequently did. I still have the photographs of those days. So to paint a simplistic picture of having a hostile attitude towards foreigners or poverty-stricken people or people on the sidewalk is simplistic. There is a much bigger issue at stake here. And I was glad to see that the editorial of one of our dailies yesterday actually very concisely unpacked that issue. I was also interested to see the comments of the portfolio chair of the National Portfolio Committee on this matter express himself on the subject, because I think everybody understands the legal issues at play here. So it's not possible for us to offer alternative accommodation, but we will assist as far as possible to find interim shelter and to reintegrate people with their homes where they were living before. Beyond that, we cannot make a special exemption. If people, and this is my final comment, if people are to be provided with a special exemption by virtue of their status as a refugee, then please understand that there is only one entity in this country who can treat them as refugees to give them a special privilege, and that is the Department of Home Affairs. If you open your Constitution and Schedule 4, you will see that the powers of every sphere of government is clearly listed, and it is only the Department of Home Affairs who, within that context, has the power to assist people in their capacity as a refugee through a reception center or other assistance. And therefore, the relief we return to court for may well include the Department of Home Affairs, who will then have to express themselves on the assistance needed for people in their capacity as refugees who currently find themselves on the sidewalk. I do want to tell you now, just before we open for questions, that we are being put under tremendous pressure from the property owners, the businesses, the employees, and others in Albertus Street. I had one lady yesterday call me absolutely irate by virtue of the fact that there was loud noise the entire night, that in the morning the entire area smelled of human ablutions. She vented much of her anger on me. I tried to explain the circumstances to her. We are now starting to have the same conversations we had at Green Market Square and all the surrounding tenants, residents, occupants, employees, traders there. We're starting to have all those same conversations again with the people in and around Albertus Street. So it will not be long before we are under very substantial pressure against there. And inasmuch as you may dismiss the issue when you think about these matters in the abstract, when you're dealing with actual humans face-to-face or in a telephone conversation, it is much more difficult to be dismissive of the issues when they explain to them what they and their children are going through. So we will we'll have to deal with that. There is a business owner who informed us yesterday and again today that he is unable to open his businesses all because the people have completely barricaded the front door of his premises, which our Metro Police will now have to deal with. But again, that causes further conflict and problems. What is evident to everybody is that it is not sustainable for people to live on the street on any protracted basis. Okay.
placing a lot of, or you putting the ball with regards to how to manage this refugee crisis, or the crisis that the city is sitting with now, on the Department of Home Affairs. But the court order that you have before you now, and in light of the fact that this is probably an issue which is not going to go away and might even grow further, how has the intergovernmental cooperation been? Is there a plan that you've been working on with them that will prevent these sorts of things from happening in the future?
Yeah, I just would like some clarity. When you head back to court, I'm not sure when you will. I think it's the 13th, or I don't know. Can you clarify that? And then up until you get to court, the refugees living outside the police station, will you do any sort of enforcement up until that time? And then last question, your engagement with SAPS. What were the reasons for them not arresting the refugees?
So I think we'll allow, who are present here, they were involved in those conversations. There were no political office bearers in those meetings, so they will have to express themselves on details that I may leave out. But Wesley, if I can say to you, the contempt of court issue was clearly spelt out in the court order. So we felt that Judge Tulare had applied his mind very significantly, had mapped out a clear pathway for how to resolve the matter, that there were no loose ends in that pathway, that it clearly explained what would happen if people resettled on public open spaces, that is precisely what happened, and that people were therefore in contempt of court, and that at that stage the SAPs then changed their position as to how they would conduct themselves. That position that they took was contrary to all the planning that had preceded for more than a week before, where we clearly understood what the approach would be, where the sheriff clearly understood what the approach would be. So we have had the goalposts moved on us. We've had people reinterpret new players in SAPS who were not part of the conversation. We also, of course, had the role of the South African Human Rights Commissioner, who reinserted himself in the conversations on Monday after having previously stepped away from the issue, saying that because of the dishonesty and the hostility, he was unable to continue. I think his statement said continue to render services to the group in question. So that was problematic. And unfortunately, the day after that, on Tuesday, when the big meeting happened, the Human Rights Commissioner was not present. So that has also created some instability. I think furthermore, and I'm perhaps preempting a portion of Kaylen's question, Kaylen, we were told that there had been a lehotla at which certain senior national figures were present, and that at that meeting they had discussed a possible solution and ways out. We were eagerly looking forward to the meeting on Tuesday, giving guidance on that and hearing what DHA had to offer, because we firmly believe, and we believe that the Constitution makes it evident that it is so, that they have a responsibility to intervene here. We, however, no such solutions or options were placed on the table. So whilst some people are eagerly looking at the city, what we are doing, I would suggest that you look as eagerly at the other spheres of government, who in fact not only have a moral obligation in every sense that the city has, but has a far clearer constitutional and legal obligation in this regard. And it is evident that national government has no intention of making any facilities available, any land available. We've called on this. We've said, Minister of Public Works, make a space available, and no such assistance is forthcoming. And I suspect for very much the same reasons that we are nervous of creating precedents, so they are anxious about doing so. We will continue with the people who are on the street. We will continue to offer them the shelter opportunities that we do have available. It is the only mechanism available to us. The 171 beds that were available as of yesterday afternoon, we will assist them in transporting them there. We are contacting and engaging the shelters, and if any of the people over the next few days indicate that they're willing to leave, we would certainly take them. It is extremely inappropriate for children to be sleeping out on the street, but they have been doing since October, and we're keen to get those kids back into some kind of formal accommodation, and certainly back into school. Aaron, the IGR, I think I've expressed myself on the role of the Department of Home Affairs. I don't think there's any doubt about it. I think anybody who understands anything about the law understands that there's no legal thing that local government can do relating to the citizenship or services relating to refugees. There's nothing in the Constitution or anything that says we can do so. If we were, for instance, to repeat Blue Waters, and I will remind you that the relocation or the accommodation on an emergency basis in terms of the Disaster Management Act at Blue Waters in 2008 cost the city 200 million rand in terms of services, which included transport, food, clothing, other intermittent welfare assistance, and that ultimately, because of what happened there, the city was required to get an eviction order in any case. So you ended up back with an eviction ultimately, and it then cost us 40 million rand to rehabilitate Blue Waters because of the damage that had been done to the facilities there. So we do not have that kind of spare facilities or resources available to do that, nor do we have the legal mechanism of the Disaster Management Act to activate that. So I think we are a bit frustrated, as you can see, by the absence of DHA in terms of solutions here. They are evidently hoping that if they delay long enough with intervening, that ultimately somebody else will find a solution and intervene and resolve the matter for them. But I don't understand or see a mechanism how that's going to happen. DHA is going to have to step forward and take ownership of the issues. Kailin, the court proceedings are on the 17th. The people on the sidewalks are now indeed in contempt of the bylaws. But I think you will also appreciate that they were voluntarily willing to go and present themselves to SAPS to be arrested. When we were on the field in Mackenzie Street, this lady sitting to my right had discussions with the refugees, and they consented not to be arrested but to voluntarily take themselves to SAPS. It is therefore a bit challenging that once they've done so by their own volition, to then present them once SAPS refuses to arrest them with the bylaw transgression. So I think we also are trying to be sensitive. We'll see how that works over the next few days, and we might have to change that position and start giving effect to the bylaws. But we also appreciate that when people have made an attempt to comply, and other agencies are making that difficult, then it is hard to punish them for that. The SAPS reasons, you will need to go and ask SAPS, but at least some of it relates to not their interpretation of not being able to arrest a woman with a child, not being able to place a woman with a child in detention. That was complicated by the fact that they apparently also said that you can't separate the woman from the child, which would mean that no woman who was with a child could ever be arrested, which clearly is not the case. There are circumstances which would require that, and there are specific facilities within correctional services that provide specifically for those circumstances that are used all the time. So the interpretation is inconsistent with it, but we are asking to see the national order in terms of which they are, or the operating procedure in terms of which they're taking their decision. Wesley, the issue of the incidents involving the journalist, I think that they are extremely regrettable. The senior staff have sent out memos and reminders to the staff to steer clear of any physical confrontation with the journalist. We have, over the years, made it abundantly clear in multiple memos to our staff that journalists are allowed to record you. So we are under no doubt about that, and the staff can be under no doubt about it. There have been multiple communiques over the years explicitly unpacking the rights of the freedom of the press. And we are happy to meet with SANEF, who have requested a meeting in this regard. There were 2 incidents. I have looked at much of the footage surrounding these incidents, and I will tell you that I have a little bit of sympathy for what the officials in this request say. Having spoken to at least 5 of the officials who were on site, and to both journalists, Kailin and Ati, who were involved in these incidents, I have a little bit of sympathy on all sides, because what the officials also say is that the journalists are not wearing any form of accreditation that allows you to see them. Yes, you may see the camera in the hand, but you may not always see it. That the situation on the street and in the park gets so frenetic or confusing at times that when a person inserts him or herself right in the middle of the action, it does become difficult to protect them and shield them from injury. So we are asking journalists that when you're at an incident like that, stand well clear of it. Put some distance between you and the incident. And it is evident from the camera footage recorded on scene that people were right in the middle of the incidents. that their hands and bodies were right in the middle of some of the incidents. So then I can understand that injuries may occur and problems may occur. So we are suggesting to journalists that they do keep a few meters away from the actions. The officials also complained that journalists were tugging on them, pulling on them, admonishing them, engaging them. And I have full respect for anybody who's there to journal an incident and make a record of it. But once you become a participant in the incident, that then engages a different set of dynamics. So we will continue to protect the rights of the journalist. We'll meet with SANEF. We'll take full blame and responsibility where it's due. And officials will be disciplined or counselled if that's necessary. Ati has laid, I think, both a criminal complaint and a disciplinary complaint. By the time she had laid a complaint, we had already initiated one ourselves. And our Safety and Security Investigations Unit is already busy with an internal investigation in that regard, but we ask that the journalist also just apply some common sense and don't put yourself in harm's way.
I'd like to do a
from Reuters. JP, just on the media, I just want to find out if there is the SAPs have a standing policy. I want to find out if Metro and the city has a standing policy of media engagement that covers the Metro Police specifically. If there is one, can we get a copy of that, please, so we can see what they're allowed to do and what they're not allowed to do. If there isn't such a standing order, please can you tell us why? The issue also about sort of accessibility. I understand things get carried away and stuff like that. But if you're not on site, you're phoning in, you say, may I please speak to the liaison officer that deals with the media on this? Essentially, there is no liaison officer. I'm hoping that this policy will then also address that fact. Who is the media liaison officer, or is the notion of responses to the media become a centralized thing that only the political head, such as yourself, who you answer your phone readily, are you the only one that can comment? And does that extend also then to operational matters? Thank you.
Hi, Jackie. Basically, my question is about this setting a precedent. There's a possibility of 160,000 foreigners. I just want to say in Cape Town or Western Cape. And we also look at international presidents being sent. If you look at people crossing the borders in other countries, because obviously this is not something actually that is going away. So is it more about like a tongue also than what is happening right now?
So Tahira, I'm not sure what has happened with the arrest cases. They were made by SAPS and not by the city. The original arrests were related to trespassing at the St. Mary's Cathedral. Those would have been for trespassing, and possibly the attacks or the resisting of arrest or interfering with an officer executing their duties by SAPS. The officials here might have more insight, but that's as much insight as I have on that matter. And I suspect that they will either have been let off with a warning by now or will have appeared by now. They wouldn't have been detained beyond this point. The city did not seek any relief inside the church. It's private property. It is the church's right, and we respect that right to offer people sanctuary. Any human being has the right to offer a charity or assistance or support to any other person. So if you want to take persons inside your home or the church wants to do so. That is their full right. There are environmental health issues, and there's been an environmental health scare. There was a diarrhea condition that swept through the facilities that affected several of the children. In the case of children, diarrhea is dangerous enough to be lethal. So the city's health department did go in there. Unfortunately, with our original attempts to help, the city officials were chased away and were threatened. But towards the end now, those relations seem to have normalized a bit. I think it is also significant that the two factions are no longer in close proximity, because part of the conflict related to the conflict between two of the refugee leaders. We did hear quite loud and clear from the refugees on the park that they no longer adhere to, support, or in any way take guidance from the refugee leadership, specifically Mr. Balu. Many of the refugees there were calling them criminals or thugs or liars. So I think that the misapprehension that the court referred to in the court's original pronouncement, when they said the refugee leaders had acted irresponsibly, had misrepresented the facts, and even with Chris Nissen having said that they lied to people as the information was being given them to UNHCR, they misrepresented the information in translation in Lingala and otherwise. When they were told there will be no relocation, they turned around and said the planes are coming. So I think that has aggravated the situation, in that people who in good faith maybe have been sitting there waiting for some relief have been misled to believe that that relief is imminent, when in fact everybody has indicated to them that it's not legally possible. This press briefing is just by the city. We didn't have a buy-in from DHA or anybody else to do a joint press briefing. The NAT joints and them did meet about this 2 days ago, and I think we would be only too happy for them to do a press briefing and unpack how they see the situation resolving itself. I did make it quite clear when I spoke that there is a standing instruction on this around the rights of the media in terms of recording incidents. So there is a standing instruction on this. It was issued by the executive director some time ago. It was repeated about a year or so ago again upon our request, and I'm sure we can get you a copy of that. However, I would prefer that we confine that engagement to SANEF as the body speaking for the journalist, and we are seeing them imminently. It was not the subject of this press conference this morning. You are well familiar with the spokespersons for the different departments. We, unlike other cities that have very narrowly restricted access to our services, we have a spokesperson for every department who is free to speak, who has enormous leeway to speak. Wayne Dyson, who speaks on behalf of law enforcement, who doesn't check what he says with me before he speaks. There's no protocol for him to get authority. He speaks off his own cuff. Ruth Solomons, who speaks on behalf of Metro Police. In each case, the chief or the deputy chiefs are authorized to speak, so you're able to speak to Deputy Chief Smith or Deputy Chief Marais or Metro Police Chief Marais, Wayne LaRue, or Law Enforcement Chief Rudolph Wiltshire. The same with Traffic, Heathcliff Thomas. They also have a spokesperson. In fact, they have two, in the form of Richard Coleman and Maxine Besaidnout. So there is a number of people who you can directly go to. If you want to speak to the politician, my phone is always on, and I do endeavor to take calls at all times, especially if they see they're from journalists. Then in terms of the 160,000 people, that's a figure that was quoted to us in briefings some time ago in relation to how many refugees and asylum seekers there are in Cape Town. It may be that the figure is for the Western Cape, but at the very least it's for the Metro and its immediate surrounds. I understand that figure is substantially bigger for the rest of South Africa, and that in relative terms, Cape Town has a comparatively small refugee and asylum seeker population relative to Gauteng and the metros there. And that's also why we're being very careful, because what happens down here will very much be precedent-setting elsewhere in the country. It was clear from the inputs of the businesses and the hotel there that people were adding themselves to the population there as it was going. That was evident from the fact that we actually saw the number of structures increase, that additional tents and structures were placed on sidewalks and in the street as time went by, but also when the interviews were done, it was evident that some people had arrived there literally from wherever destination outside of South Africa they came from had gone directly to Green Market Square, saying that they were told that if you arrive at Green Market Square, you will be getting housing. So I think that the precedent was not just a theoretical construct, it was actually happening already. And you can see that from the fact that the numbers grew by 100 between the survey we did shortly after the settlement in front of the church and the survey that was done during that process. And I should point out that not everybody at the church and in front of the church opted to go to that survey. So if that figure is complete, it will probably be a good 50 or 100 or so more. So a significant number of people joined that process, probably between 100 and 200 people. I'll try and be quick with my answers. I think that you can absolve yourself of whatever you want in whatever forum you want, but ultimately you have some responsibilities. We explore our legal responsibilities often. We're in court cases, we're in discussions, we're in policy processes. Over the years, you get a good handle or a grip on what your responsibilities are. The Constitution is my guiding document. I flip that open whenever I'm in doubt, and I go to the schedule of powers and mandates. And I can only see one entity in this country that has a mandate to give assistance and relief to the refugees in this regard. I think that they've interpreted that mandate very narrowly, especially in this regard. And they have been criticized extensively for it. So maybe it is part of that relief might need to go and test the interpretation of that mandate. The court has said that we can return to court in terms of Clause 6 for further relief if there's contempt of court, and we may need to do that now in relation to DHA's role. I think that there will be people in the meantime who will accept reintegration and we'll assist them. So I'm expecting that figure of 200 to reduce somewhat. But as I said, that's complicated by the fact that leaders are putting pressure on people not to leave, and that the attorneys have now entered the fray who are also advising their clients not to leave, even though we're being told face-to-face to officials as recently as Sergeant Samanga this morning was told by people that they would like assistance with returning to where they stayed previously. Natalie, the reintegration, in the survey, one person that I saw, I don't know if you subsequently when that was on the preliminary document, because when we were asked to go to the meeting, the full capture of all the surveys had not been completed. When we scanned that, only one person had said that they were willing to accept reintegration. The others were holding out for onwards relocation to a third country. Most did not believe that life in South Africa was viable or feasible, that they were the victims of hate or discrimination too often in their estimation. So we will have to see what comes out of that process. It's also in many cases was difficult to corroborate because people didn't want to give addresses. So if they claim a particular incident happened, one would have to take their word for it. That without an address, it's hard to corroborate those incidents. The people being on the street and deportation, I don't know that is a viable option. I don't think the South African law permits for that. It appears that the law does not permit for the deportation, even under circumstances where people are breaking the law. So if you break the law and you commit an offence, it appears that the Immigration Act doesn't provide for deportation under those circumstances, to the best of my knowledge. Certainly Home Affairs' approach was not to deport anybody who was not documented. So I hear that you said that only a much smaller number of people originally were indicated not to be documented. That, correct, 68. By the time the survey was complete, and having seen them one-on-one and face-to-face, that figure had changed, as I said to you, to, let me just get my numbers in front of me, to 236 that had no demonstrable papers. So that either destroyed the papers so as not to be identifiable or didn't have papers at any point before that. Only DHA will be able to tell you what that situation was. And it was not the approach of the Department of Home Affairs to deport people who were not legally here, but rather to give them documentation. They had, I think, 14 days to submit that, to make an application and to give cause why they should be given asylum status, or otherwise I wouldn't be able to tell you whether DHA has had any takers on that. Let's start from the back quickly with the children issue. We have consulted DSD. They do not believe that it's appropriate to remove children from their families, and I concur with that. They're looking at it from a legal perspective. I'm telling you, giving it to you from a moral perspective, that you don't remove children from their parents unless it's absolutely necessary, where the parents are unfit to care for the children. They say it's not desirable to remove a child unless it is completely unavoidable. The people, what Section 4 required of the city and DHA was to screen all the persons, to understand what their circumstances were, and where, and the words that the court order used, is where people demonstrated particularity of reasons why they could not return, which only a small number did, and where they complied with the rest of the details and information that they had to supply, which an even smaller number did. Those persons we must assist within our policy framework. So what is our policy framework in this regard? Homeless shelters is what we have available. What is outside of our policy framework would be to make a special dispensation for refugees. In other words, to say, well, you're a special case. For you, we are going to ignore the waiting list. We're going to ignore the other protocols. We're going to give you special treatment, and we are going to build facilities for you or give you stands or whatever. That would be precedent setting, and the precedent would apply across South Africa and would apply to many more people than are just the subject of these court proceedings. And so we have to proceed with great care. It is also just financially not readily possible. We're in a state in the financial year where we're 2/3 through the financial year. Budgets are determined in the beginning of a new financial year. I don't know how you think local government works, but there aren't large pots of spare cash sitting around that you can initiate interventions with. Interventions have to be pre-planned. The contingency funding for these things is small, and you will know that currently, even on the emergency housing, even for emergency housing, there is a backlog within government across South Africa, and that includes in Cape Town. I do believe that if we go to court, it will be in part to clarify the role of the DHA and SAPS in this regard, in terms of what they'll do. It cannot be that your criminal justice system has no mechanism for people who are in contempt of court. I think this is a case, as with many other cases I could unpack for you if you had the time, of the frailty of the criminal justice system and its inability to respond to decisions of the court, etc. I must also tell you from the city, it's for us very difficult because you're getting such contradictory instructions and direction from national ministers from one moment to the next. At one moment, a national minister will talk to you about not enforcing your bylaws about people sleeping in a park or on a sidewalk. And the very next minister will demand that you do so. The National Minister for Home Affairs sent us a strongly worded letter about, he insists that the city enforce its bylaws. Why are we going to court? We must just enforce our bylaws for people who sleep on the street. Judge Tulare called us out for not having enforced our bylaws. Judge Martins, in a preceding case, had a very different take on it. So I must tell you, we exist within an environment that is so contradictory with legal opinions and guidance that I don't know how they expect local government to make sense of it all. Wesley, I don't know what the cost is. I don't know that we've done a cost estimation. Most of these are not quantified as a specific cost item on a line that you can go and add up. But, I mean, if one had to estimate the time and energy of operations relating to that, it's going to clock up into the hundreds of thousands of rands. You'll probably spent around this stage about $500,000, at least 500,000 rand or so on overtime and operations cost. Deputy, probably in that vicinity. So I'd guess somewhere between 300 and 500,000 rands worth of operational costs that you've paid staff on overtime, in addition to normal salaries, which you wouldn't easily be able to quantify, not without a huge amount of administrative effort. We have made also available vehicles and transport, which you could probably quantify as well, to transport people. We, on 2 occasions before the court made its ruling, made vehicles available from disaster management, unbranded vehicles and otherwise, so that people wouldn't feel awkward, which they could come to, be assessed, get assistance, and be relocated. And in terms of the backup plan, it's now up to clause 6 of that interim order for us to get clarity on the role of DHA. These are precedent-setting manners, so you will forgive me if I don't have the wisdom of Solomon in this regard, because apparently not even Judge Tulare has. Nobody knows the answer to this situation. This is the first time that we are wrestling with it, and whatever comes out of this is going to, South Africa will live with for quite some time, and will have significant financial implications. Because if for the small number of people, to take them, accommodate them at Soetwater or Blue Waters, it costs 200 million, and you extrapolate that to the potential consequences and precedents at play here, you could look at very, very substantial amounts of budget. And then the question is, would national government supply that funding? Would there be grant funding for it? And in terms of the housing policy, the answer is no. This wouldn't meet the requirements of the housing policy. Last time when we had the 200 million rand expense in terms of the Disaster Management Act, you should remember that national government only returned 17 million of that 200 million to the city. Maybe not in a manner that you understood to relate to your question. So what the order said to us is that we must understand who is not able to return. They must give us good explanation for why they can't return to where they were in October. It's the logical thing. If a South African came to you tomorrow and said, as I said to you, I can't find a job, I don't have a good house, or I don't have a house I can live in, I'm really struggling, give me something. What is that something that we can give them? What is that mechanism we have available for them? And the only mechanism other than on a housing waiting list and a formal housing opportunity, in terms of the national housing policy, remember, we We don't make these things up as we go along. We have to act in terms of national policy and law in this regard. Is a homeless shelter, night shelter. So we were asked to identify who could not return by virtue of threat to their life to where they were living before. And keep in mind, there were no xenophobic incidents that precipitated these matters that are on any form of record. And in those cases where people then gave details, were willing to give an address, etc., when you apply those criteria, the number of people who actually ask for that kind of reintegration is in the vicinity of about 20, 30 people. So you're talking about a very small pool of people who actually did what the court order said that they must do. And those we are very happy to accommodate within the policy framework that we have, and that policy framework is night shelters. Hence going there yesterday and loud hailing to them about the 171 beds that are available, which we're willing to transport them to immediately. Dynamic in that when you have conferences like that, people gatecrash your conference, you not end up speaking to the media, you end up having a dialogue with somebody who uses the platform to express their particular views. Anybody who speaks on the media, but they must do so by their own means.
That's not how they understood it downstairs side of things. They didn't implement it as what Masini suggested.
But can I say that maybe all of you, because we have you now, in terms of accreditation or credentials, maybe you should be developing something clear from your media houses that says, I'm a journalist on behalf of X, something that's readily and clearly identifiable. So when we're in circumstances where there is confusion, that it's easy to identify who the journalists are. You don't have to wear it all the time, but in circumstances that it is possible to say who is journalist and who is not. It does become confusing. Some kind of staff
and then when you freelance, and then if you're a freelancer, what?
No, they just have to have basic respect for us. That's all we're asking.
Understand? So it's like